Hello everyone, welcome to an Eltoma webinar. My name is Lucas Andreas Mavrocordados and I am a Senior Legal Advisor at Eltoma Cyprus Limited. Today's webinar, as the title suggests, will cover the fundamentals of international trust law and foundations. If you have any questions during the presentation, please write them in the chat box provided and we will respond to them via email after the completion of this webinar. So let's get started. Trusts and foundations became popular in the Middle Ages to protect people's assets and ensure the smooth transfer of family wealth to the next generation. These concepts then evolved over time based on English common law. The need of high net worth individuals to protect their property led to the development of the modern offshore trust legislation that we are familiar with today. So, what is a trust? A trust is a relationship whereby property is held by one party for the benefit of another. The uses of trusts are many and varied, and their creation can satisfy both personal and commercial reasons. Some of the most common uses for trusts in the modern offshore trust legislation include privacy, wills and estate planning, asset protection, financial and tax planning. It should be noted that property of any sort may be held in a trust. There can be living trusts, also known as inter vivos trusts, we'll see these a bit later, which are created during a person's lifetime through the drafting of a trust instrument, or testamentary trusts, which are created after death in a will. A foundation is usually created where a jurisdiction does not recognize trust law or where the intention is to accept contributions from multiple donors. It is said to be a corporate alternative to a trust as it keeps the main characteristics of a trust while holding additional benefits on a corporate scale. We will cover a bit more on foundations later in the presentation. Bringing now our attention to trusts. A simple definition of a trust is that a trust is a legal arrangement through which a person referred to as the settlor introduces an equitable obligation by entrusting assets to another person referred to as the trustee to manage for the benefit of other persons referred to as the beneficiaries, where all and any of whom may enforce the obligation. Therefore, we can identify from the definition that a trust is a relationship whereby assets are held by one party for the benefit of another. The trust is created by the settlor, also known as the grantor, who transfers or entrusts the assets to the trustee. The trustee then holds that property for the trust's beneficiaries. We will talk more about each of these roles in more detail in the following slides. The trust concept has been developed, enacted, and is mainly found to exist in common law jurisdictions with similar systems dating as far back as the Roman times. Moving on to the types of trusts. There are many different types of trusts depending on the characteristics or the purpose of the trust. Because trusts often have multiple characteristics or purposes, a single trust may accurately be described in several ways. For the purpose of this presentation, we're going to talk about the most common types of trust. In a discretionary trust, certainty of object is satisfied if it can be said that there is a criterion which a person must satisfy in order to be a beneficiary. For example, whether there is a class of beneficiaries which a person can be said to belong to. In that way, persons who satisfy that criterion, who are members of that class, can enforce the trust. The inter vivos trust or living trust. A settlor who is living at the time the trust is established can create an inter vivos trust, which is different from the testamentary trust, which is created with a will, that we will see a bit later. The irrevocable trust. In contrast to a revocable trust, an irrevocable trust is one which its terms cannot be amended or revised until the terms or purpose of the trust have been completed. Although in rare cases, a court may change the terms of the trust due to unexpected changes in circumstances that make the trust uneconomical or unwieldy to administer. Under normal circumstances, an irrevocable trust may not be changed by the trustee or the beneficiaries of the trust. Moving on, a purpose trust, or more accurately, a non-charitable purpose trust, since all charitable trusts are purpose trusts, and those are commonly referred to as charitable trusts. Generally speaking, the law does not permit non-charitable purpose trusts outside certain anomalous exceptions which arose by common law developed in the 18th century. Certain jurisdictions, typically offshore jurisdictions, have enacted legislation validating non-charitable purpose trusts. We will revisit and discuss this type of trust in more detail later in the presentation. In settler-directed trusts, the trustee is directed by a number of other trust participants in implementing the trust's execution. These participants may include a distribution committee, a trust protector, or investment advisor. The directed trustee's role is administrative, which involves following investment instructions, holding legal title to the trust assets, providing fiduciary and tax accounting, coordinating trust participants, and offering dispute resolution among the participants where required. Let's now go through a few more generic characteristics of a trust. As mentioned at the beginning of this presentation, a trust is an agreement between a settlor and trustee to hold property in trust for the benefit of the beneficiaries. It should, however, at this point be noted that a trust may have multiple trustees, and these trustees are the legal owners of the assets under trust. However, they have a fiduciary duty to the beneficiaries and various other duties, such as a duty of care and a duty to inform. If trustees fail to adhere to these duties, they may be removed through legal action. The trustee may be either a person or a legal entity, such as a company, but typically the trust itself is not an entity and any legal action is taken against the trustees. A trustee has many rights and responsibilities which can vary depending on the jurisdiction and trust instrument. The validity period for trust can be looked at further by examining the rule against perpetuities, which we will see later on in the webinar. Saunders and Vautier is a leading case in English trust law. It laid down the rule of equity, which provides that if all of the beneficiaries in a trust are of adult age and under no disability, the beneficiaries may require the trustee to transfer the legal estate to them and thereby terminate the trust. In that case, the assets of the trust are distributed to the beneficiaries in accordance with the wishes of the beneficiaries, notwithstanding the settlor's different intention when forming the trust. So, what are the key roles involved to establishing a basic trust? Firstly, there is the settlor. He's the person or she who creates the trust. They are also known as the grantor or the donor. The settlor then transfers the assets to a trustee. The trustee is also known as the executor of the trust. The trustee or trustees can be individuals or entities, for example, banks or other corporations, holding assets on the behalf of the beneficiaries who are to benefit from the trust. In some scenarios, you can also have a protector who ensures that the trustees are acting appropriately and in the best interest of the beneficiaries. In a will, a testator is a person who has written and executed the will and testament that comes to effect at the time of his or her death. It is any person who makes a will. We will discuss all of these roles and their relation to trust in more depth later on. For the trust to be valid, the property must be transferred from the settlor to the trustees, and to do this under trust, there are three commonly used methods. The first of which being through the use of a trust instrument, which is also referred to as a deed of trust where executed by way of deed. The trust instrument is an instrument in writing executed by a settlor used to constitute a trust. Trust instruments are generally only used in relation to an inter vivos living trust, as we've seen before, also referred to. The second method to create a trust is through a statement made by the owner of the asset that the asset is being held for the benefit of another person. This is also called a declaration of trust. The asset is placed in a trust where a trustee is appointed to oversee the asset. The declaration of trust outlines who the trust is in benefit of, who can amend or revoke the trust, if it can be amended at all, who will serve as a trustee, and what powers the trustee holds, and information regarding what is to happen if a beneficiary wants to receive distributions. The third method is through a will, also known as testamentary trust. A testamentary trust is a legal arrangement created in accordance with a person's will, and it is formed with the death of that person. It is created to address any estate accumulated during that person's lifetime, with the main difference from other types of trust being that he or she will generally not have any influence over the trustee's exercise of discretion. In order to create a trust, the settlor must have the legal capacity to do so. Therefore, the following requirements shall be met. The settlor must be a legally competent person with capacity to manage his own affairs by being an independent and legally able person. Therefore, this person must satisfy the personal traits, of being of sound mind and of age. For example, to be 18 years old, and proprietary traits to own the assets in question and have the rights to transfer them into trust. Common law and local jurisdiction law prescribe how title to each type of assets should be transferred and which law will govern the transfer of the titles to the assets. To ensure that the trust created is valid, there need to be evident three certainties. This really is a fundamental rule in trust law, and it is crucial in determining whether you have created a valid, binding, and legitimate express trust. Lord Langdale first conceptualized the three certainties in the landmark case of Knight versus Knight, where he recognized that in order for a trust to be valid, the trust instrument must have a certainty of intention, certainty of subject matter, and certainty of object. Certainty of intention means that it must be clear that the donor or testator wishes to create a trust. This is not dependent on any particular language used, and a trust can be created without the word trust being used, or can even be created without the donor knowing that he is in fact creating a trust. Certainty of objects means that it must be clear who the beneficiaries, being the objects of the trust, are. The test for determining this differs depending on the type of trust. It can be that all beneficiaries must be individually identified, or that the trustees must be able to say with certainty whether an individual satisfies all requirements to be considered a beneficiary. Certainty of subject matter means that it must be clear what assets form part of the trust. Historically, it was recognized that assets under a trust must be separated from non-trust assets. However, more recently, the courts have drawn a line between tangible and intangible assets, holding that with intangible assets, there is not always a need for separation. Moving on, we will now cover the roles of the previously mentioned main elements of a trust. Firstly, the settlor, which again you may hear being referred to as the grantor or donor. The settlor, in some instances, may also be the trustee of the trust, where he declares that he holds his own property on trust for the benefit of another. The capacity to be a trustee is generally coextensive with the ability to hold and dispose of a legal or beneficial interest in property. In practice, special considerations arise only with minors or mentally incapacitated persons. After the point of initiation, once all power is transferred, the settlor is no longer needed. On the slide, you can see an outline of the duties of the settlor, as already mentioned. It is important to note that the point that the settlor may reserve some powers when creating the trust However, this could lead to a trust being declared as a sham and considered invalid. We will now briefly go over the general duties of trustees, starting with an overview of the trustees' duty of care. Trustees have a duty of care to the beneficiaries, which includes the following: carrying out the express terms of the trust instrument, defending the trust, sensibly investing the assets under trust, being impartial among beneficiaries, being accountable for all actions taken, be loyal and keep the beneficiaries informed, not profiting from the trust or take advantage of the trustee's position. However, the trustee can charge fees for the services, especially when it takes a lot of his time or her time. Not being in a conflict of interest position and always acting in the best interest of the beneficiaries. In addition to the duty of care, trustees also have a fiduciary duty to the beneficiaries. A fiduciary is someone who has undertaken to act for and on the behalf of another in a particular matter in circumstances which give rise to a relationship of trust and confidence. This duty was defined by Lord Millet in Bristol and West Building Society versus Mothew as being the highest standard of care at either equity or law. A trustee carries the fiduciary responsibility and liability to use the trust assets according to the provisions of the trust instrument, and often regardless of their own or the beneficiary's wishes. The trustee may find himself liable to claimants, prospective beneficiaries, or third parties. It should be noted that in the event that the trustee incurs liability, for example, in litigation or for outstanding taxes or under the terms of a lease, in excess of the trust property they hold, they may be found personally liable for such excess. Moving on to the beneficiaries and their rights under a trust. A beneficiary will normally be one or more natural person or persons. However, it is possible to have a company as a beneficiary of a trust, and this often happens in more sophisticated commercial transaction structures. With the exception of charitable trusts and some specific anomalous non-charitable purpose trusts, all trusts are required to have ascertainable beneficiaries. The nature of a beneficiary's interest in the trust fund varies according to the type of trust. For example, in the case of a fixed trust, the beneficiary's interest is proprietary, meaning that they are the owners of an equitable interest in the property held under the trust. The position is slightly different in the case of a discretionary trust. In such cases, the beneficiaries are dependent upon the exercise by the trustees of their powers under the trust instrument in the favor of the beneficiaries. Similarly, where a trust gives rise to a successive interest, the title of a remainder man is a prospective or contingent interest. Although, unlike a discretionary beneficiary, this is still a type of property that can be dealt with, much in the same way as a contingent or prospective debt. We previously mentioned the trust instrument, so let's now see what makes a trust instrument. As mentioned before, a trust instrument is the legal document which can take the form of a will, deed, agreement, or a declaration of trust by which trust is created. The trust instrument states who will manage the trust, how it is to be managed, and who will gain from it. And its main provisions include the following. Creation of a trust of original and additional property. Here we would need to ensure that the three certainties mentioned before are present and clear. It includes dispositive provisions, administrative provisions, provisions for the protection of trustees, the remuneration of trustees, provisions for the retirement, removal, and appointment of trustees, the proper law, jurisdiction, forum, and administration. These will be analyzed in more detail in the following slides, starting with the dispositive provisions. So there are two types of dispositive provisions, and these are dispositive duties and dispositive powers. Dispositive provisions consist of the provisions of a will or trust agreement relating to the disposition and distribution of the property in the estate or trust, to be distinguished from administrative provisions which relate to the handling of the property while it is in the hands of the executor or trustee. We will see administrative provisions in a moment. To clarify, dispositive power consists of the discretionary power conferred onto the trustee by the settlor, enabling the trustee to be able to make a distribution of income or capital out of the trust fund. And the dispositive duties of the trustee consist of the following: that the trustee needs to consider whether distribution of income or capital is required, how the settlor wishes the trust property to be distributed, and what power the settlor has given to the trustee. The dispositive provisions of a will are the provisions that dispose of the testator's property. These provisions vary considerably as they are drafted to meet the needs of each individual settlor. Here we're looking at the administrative provisions which regulate the powers or duties that the trustee has over the assets in trust. So what are these provisions? Provisions relating to the management of the trust. For example, the power of the trustee to invest the trust property in order to generate more income or capital gain for the beneficiaries. Provisions relating to the distribution of the trust's capital or income to beneficiaries at the trustee's discretion, and provisions relating to the trustee's power to act as administrator of the trust, where a trustee can exercise all powers conferred as per the terms of the trust, as well as any powers not limited by statute. Essentially, as long as the trustee acts in the best interest of the fund, anything to ensure the value is maintained or I'll repeat the sentence. Essentially, as long as the trustee acts in the best interest of the fund, the trustee acts in the best interest of the fund to ensure that value is maintained or expanded. One example of this can include the situation where the value of the trust depends on the fluctuation of currencies. In this case, trading of currencies may be required to ensure that the value increases or remains the same, or if there is expected loss, that this loss is mitigated. Trustees are generally not able to be the administrators of the trust unless they are impliedly authorized by common law or statutory provisions, or expressly through a provision in the trust instrument. You can see the main administrative powers of trustees on the slides. In addition to these, there is also the power to appropriate and distribute in specie, the power to vary administrative provisions, and the power to pay taxes. We mentioned before that trustees can be found liable for any excess liability over the value of the trust. So how are trustees protected in the event where something occurs which devalues the fund? There are two ways through which trustees are generally protected. The first is through an indemnity agreement, whereby the trustee is reimbursed against all claims, expenses, and other costs which may occur during the administration of the trust. This is very important, taking into consideration that making an error on a seemingly minor decision can put trustees at significant risk of compensation claims, legal action, or official investigations being directed towards them in their personal capacity. Without this, the trustees themselves may be liable to pay the costs to defend any claims personally. The purpose of the indemnity is to reimburse any legal costs and expenses of defending against disqualification as a trustee, investigations into the trust fund, or extradition proceedings. An indemnity cannot be activated where the trustee has acted negligently. The second way is with an exoneration, either clause or agreement, where this exoneration is the full release of the trustee from any liability for negligence and breach of any duty of care owed to the beneficiaries. Of course, liability in cases of willful misconduct, default, fraud, and dishonesty cannot be exonerated, and the trustee will be found to be liable for the mismanagement of the trust. It is reasonable, as mentioned before, that sometimes trustees feel that they should be compensated for the work they do, especially since in some cases a significant amount of time has been spent. The general rule is that trustees are not allowed to take benefits in form of compensation, remuneration, or salary. This, however, depends on what constitutes a benefit. In most instances, reasonable is defined as a fee no higher than the prevailing average market rate. Therefore, in such cases, remuneration would be permissible, and it is customary to be used under certain circumstances. Moving on to the appointment of trustees. There are two ways to appoint a trustee, and these will depend on the type of trust created, whether inter vivos or living trusts, as mentioned, or testamentary trusts. The trustee of an inter vivos trust derives his or her authority from the trust instrument itself and administers the trust without supervision of the court. Testamentary trustees derive their authority from court appointment. Usually, the court appoints the trustee as named in the will. It is important for the trustee to ensure that all know your client and customer due diligence checks have been performed before accepting his or her appointment. Let's now briefly cover the provisions for removal and retirement of trustees. As we can see, under common law, existing trustees can be removed only with a just case if the trustee is deceased, remains outside of the jurisdiction for 12 months, is unfit, unwilling, incapable of acting, or has been removed by power of trust instrument. In modern offshore trust legislation, these conditions and requirements are repealed, and it is allowed for the removal of existing trustees. Yes, it allows for the removal, direct removal of existing trustees. This may be required for trusts designed for asset protection, which we will cover in more detail further on in this presentation. Because a trust cannot remain without a trustee, in order to resign, the trustee needs court permission unless the trust agreement contains a conflicting clause or provision to the contrary. In Blumenstiel versus Morris, it was ruled that the court may remove a trustee for any one of numerous grounds, such as dishonesty, incompetence in handling of trust property, or dissipation of the trust estate. It is recommended to appoint two trustees where possible. In that way, in the event of a the unexpected removal of a trustee, or if any problem arises with one of the trustees, such as failing to qualify or declining the appointment, the co-trustee will be automatically appointed and the trust will not fail for lack of a trustee. We will now move on to the last of the provisions mentioned before and included in the trust instrument, consisting of the proper law, forum, and administration. Conflict of laws rule determines treatment of an issue relating to a particular transaction or occurrence. For example, capacity of settlor, validity of trust and dispositions into trust, prescribed formalities for the transfer of title of an asset, testamentary issues, etc. Conflict of laws or private international law, both terms are used interchangeably, concerns relations across different legal jurisdictions between persons and sometimes also companies, corporations, and other legal entities. Conflict of laws rule deal with an overlap of legislation in different jurisdictions. So, for instance, if you own property in two jurisdictions, for example, in the UK and Portugal, where UK uses common law, Portugal uses constitutional law, it is a matter. It's a question of which precedent will be overruled and which will prevail. In order to understand which law will govern an issue or occurrence, an appropriate analysis should be conducted. When the courts of one jurisdiction are considering the application of the laws of another jurisdiction, the doctrine of Renvoir can be applied. Renvoir translates from French to send back or to return unopened, and is applied by courts when considering foreign issues arising in succession planning and in administrating estates. Modern offshore trust law can assist the governing body to decide on the capacity of a settlor to set up a trust, validity of a trust and dispositions of property into trust, administration of trust, reserved powers by settlor and their extent. However, there are matters to be decided in accordance with the national law of different jurisdictions, and therefore modern offshore trust law cannot decide on such matters. These consist of transfer of foreign real estate into trust, which formalities to be met for transfer of assets into trust, testamentary arrangements, transfer of property into trust by a company. Lex situs is a conflict of law rule that selects the applicable law based on the venue or location of something. Because these are definitions you can see on the slide, and as mentioned, lex domicili, when all the main features of the case are locally called, will apply. This to apologies for the delay. Seems that my notes are not very clear on this. However, it is the law applied where the location of the assets is. So moving on. With regards to this, to the application of the law and this provision of the trust instrument, should be noted that the choice of law under common law is regulated by connecting factors such as nationality, place of domicile, place of property transfer, etc. And the choice of governing law as per modern offshore trust legislation allows for a free choice of governing law for trust. Moving on, we will now go through asset protection trusts, purpose trusts, and foundations, starting with asset protection trusts. An asset protection trust is a term which covers a wide spectrum of legal structures. Any form of trust which provides for funds to be held on a discretionary basis falls within this category. Such trusts are set up in an attempt to avoid or mitigate the effects of taxation, divorce, and bankruptcy on the beneficiary. Such trusts are therefore frequently prescribed or limited in their effects by governments and the courts. It is worth noting that with an asset protection trust, the settlor and beneficiary can be the same person, and the trustee is typically a licensed insured company that has a written duty to protect the assets from creditors. Forced heirship is generally a feature of civil law legal systems which do not recognize total freedom of testation. Normally, the deceased estate is ingathered and wound up without discharging liabilities, which means accepting inheritance inherited property. The forced estate is divided into shares, which include the share of issue and the spousal share. This provides a minimum protection that cannot be defeated by will. The free estate, on the other hand, is at the discretion of a testator to be distributed by will on death to whomever he or she chooses. Takers in the forced estate are known as forced heirs. Advocates of forced heirship contend that it is perfectly proper for testators to be required to make adequate provision for their dependents, and that most countries in the world permit wills to be varied where they would leave dependents destitute. Critics suggest that there is a great difference between varying wills to the minimum degree to provide sufficient financial support for dependents and prohibiting the testator from distributing the estate or a proportion of the estate to any female children or younger male children, and that it cannot be any less repugnant to force a deceased person to distribute their assets in a certain manner on their death than it would be to tell them how they may do so during their lifetime. Because no trust can be set aside by a disinherited heir, the trust property can be protected efficiently using an asset protection trust. Here are some ways that a testator could exclude someone as an heir or a beneficiary under a will. They could expressly state that an heir is excluded. They could state that the heir is excluded and state which heirs are to receive the testator's property. Yes, the excluded heir could be treated as though he had died before the testator, with his share of the property passing to his children. So basically, bypassing the first heir and moving on to his children. And in some cases, the testator can merely disinherit the excluded heir by leaving him out of the will and not mentioning him at all. However, this is not accepted everywhere. In common law, it should be mentioned that a claim from a disinherited heir could be satisfied. Offshore trusts and other asset protection vehicles typically do not prevent action against the individual concerned in his or her home country. Orders under divorce and creditor protection laws can typically be made against that individual, notwithstanding the alleged independence of such trustees. If a judge determines that the trust settlor controls the assets of the offshore trust, the judge may order the settlor to repatriate the trust assets. Failure to comply with the court's order may lead to a finding of contempt of court and imprisonment. For this reason, a properly established asset protection trust should provide a clear separation between the settlor and those who exercise control over the trust assets. The Fraudulent Conveyances Act, also known as the Statute of Elizabeth, voids a transfer to a trust if the transfer could be interpreted as intention to hinder, delay, or defraud creditors, including potential future creditors. Some offshore financial centers have declared the Statute of Elizabeth null and void in their trust legislation. In appropriate circumstances that have the effect of allowing a creditor who may not have existed at the time of the creation of the settlement to set aside a disposition to trustees, can leave the trustee in a position of not only receiving minimal or no fees to cover the professional trusteeship, but also possibly out-of-pocket expenses for defending the trust. We can see here the differences between the Statute of Elizabeth and the modern English legislation. And modern offshore trust legislation. So, how are trusts treated if the settlor is defeated under the Statute of Elizabeth? In this case, the trust would be considered as void from the beginning. The trust funds will revert to the settlor's estate in order to satisfy creditors' claims. The trustee has to reimburse all unrecoverable distributions, and the trustee bears the legal cost. The differences with the modern offshore legislation, where the settlor is defeated, the trust funds are set aside only in proportion to satisfy claims. The trust remains valid. There's no need to reimburse distribution carried out bona fide, and trustee entitled to be reimbursed for legal expenses from trust fund if acted in a bona fide manner. The trust law enters civil jurisdictions through the conflict of law arrangements, recognizing it as a matter of private international law, and has been implemented in civil court in certain jurisdictions. However, civil law doesn't really recognize the concept of trust law, leaving asset protection trusts vulnerable. There are certain remedies which are available to safeguard trust funds against abuse by having the following structure. By implementing these provisions or following these types of trusts, we can ensure that these trusts are more secure. So what can be included is a flight provision, which can allow for a change of governing law by the trustees. Which can protect against changes in the law of the jurisdiction in which trust created or the property located, if there is civil unrest or political change. An irrevocable trust can be created. The settlor can limit or exclude completely any powers to the management of the trust. A discretionary trust can be created, and the trust and trust fund can be located in a jurisdiction far away from the place where the settlor resides. To conclude with asset protection trusts, In order to ensure validity of the asset protection trust and ensure its protection, the following rules must be adhered to. Trust to be established when settlor is solvent. Trust funds should not be comprised of all or nearly all the settlor's property. There should be no unknown and or unsettled creditors. A proper structure should be followed, as mentioned previously, and all formalities for property transfer to be sufficiently met. Moving on from asset protection trusts, we'll now go through what constitutes a purpose trust. A purpose trust in English law is a trust created for the fulfillment of a purpose, not for the benefit of a person. With the exception of charitable trusts, these are normally considered invalid by the courts, often because they have no beneficiaries and therefore nobody who can enforce the trust. There are, however, several exceptions to the rules against purpose trusts. If the requirement to fulfill a purpose is a request rather than an obligation, the trust is valid. A purpose trust will also be found valid if it involves beneficiaries in some respect. Purpose trusts can also be valid if they are for the building or maintenance of tombs and memorials, the maintenance of the maintenance of animals and arguably the celebration of masses, although these must all obey the rule against perpetuities and not constitute for more than 21 years after the testator's death. Charitable trusts are exempted from the above and can be valid. Charitable trusts are enforced by the Attorney General, and there is no time limit and can continue in perpetuity while they continue to satisfy their purpose. For such charitable trusts, the Cyprus doctrine, which means as near as possible, can also be applied, and it applies when the original objective of the settlor or the testator has become impossible, impracticable, or illegal to perform. The Cyprus doctrine allows the court to amend the terms of the charitable trust as closely as possible to the original intention of the testator or settlor in order to prevent the trust from failing. We can see here on the slide normal uses for the purpose trust. The introduction of the Trust Special Provisions Amendment Act of 1998 refined the law relating to purpose trusts created for non-charitable purposes by requiring the following conditions to be satisfied. The purpose or purpose of the trust must be sufficiently certain to allow the trust to be carried out. And the trust must be lawful and it must not be contrary to public policy. Let's see now a couple of examples, starting with the law in Bermuda. Here, a purpose trust may last indefinitely or for a specified term of years. Hybrid trusts with both purpose and beneficiaries are permitted. The trust deed may provide for the appointment of an enforcer, which is a role that is similar to that of the protector. However, the appointment of an enforcer to enforce the trust and provide for the appointment of successors is not a requirement in purpose trusts governed by Bermuda law. The Trust Special Provisions Act provides the settlor, a trustee, or any person with sufficient interest in the trust, the power to make application to the court to enforce the purpose trust. In default of any other arrangements, the final power of enforcement rests with the Attorney General. Moving on to the example of Cayman Islands and the creation of the Star Trusts. Here we will see, we will cover why such Star Trusts were created. Before the Star Trust legislation was enacted, there were identified four main limitations in trust law in the Cayman Islands, and the enactment of the Star Trust law was aimed at eliminating these limitations. Briefly, the limitations were that it was not possible to create trusts for a purpose other than a charitable purpose, as was defined under the law of England and Wales. All Cayman Islands trusts were subject to the rule against perpetuities and thus were limited to a maximum duration of 150 years. The beneficiaries acting as a whole could vary or terminate a trust if they all agreed to do so, so long as they were not impaired by any incapacity, as shown in the Saunders and Vautier principle that we saw earlier. And lastly, there was no mechanism whereby a trust could permit both persons and purposes to benefit. The legislation was drafted to address these limitations and to create a flexible, unique, and adaptable form of trust that could be used in many commercial and estate planning applications, the full scope of which is only now being explored. Finally, moving on to foundations. The term foundation in general is used to describe a distinct legal entity. Foundations are formed and consist of legal persons resembling companies and may have a diversity of forms and follow diverse regulations depending on the jurisdiction where they are created. In some jurisdictions, a foundation may acquire its legal personality when it is entered in a public registry, while in other countries, a foundation may acquire legal personality by the mere action of creation through a required document. Unlike a company, foundations have no shareholders, though they may have a board, an assembly, and voting members. A foundation may hold assets in its own name for the purpose set out in its constitutive documents, and its administration and operation are carried out in accordance with its statutes or articles of association rather than fiduciary principles. The foundation has a distinct patrimony independent of its founder. Foundations are often set up for charitable purposes, family patrimony, and collective purposes. A foundation requires the need for a founder, a protector, beneficiary, and council members. The Foundation Council directs and manages the foundation's activity, while the protector protects the assets and ensures compliance with foundation legislation in that particular jurisdiction. The founder is, of course, the person or group who seeks to create the foundation, while the beneficiaries are those people who will benefit from the foundation's operations. Usually, a foundation is created where a jurisdiction cannot recognize trust law, and it is said to be a corporate alternative to a trust, as it keeps the main characteristics of a trust while holding additional benefits on a corporate scale. Finally, and to conclude this webinar, these are some final points regarding foundations. In foundations, the powers are reserved by the settlor without invalidating foundation. The foundation may have a protector or guardian. Beneficiaries have limited, if any, proprietary rights in assets of the foundations, and the foundation is liquidated in the same way as a company. Before closing, I would like to share with you some information about the Eltoma Group. Here is a summarized list of the main corporate services which we provide. In addition to the corporate services, the Eltoma Group has expanded to deliver custom recruitment services to support employers within the Cyprus market to help during the process of locating and selecting the best person for a given position. Eltoma Recruitment now offers a cost-effective solution to satisfy all your requirement needs, an ideal way to gain access to our increasing local CV database, zero fees without making a successful placement, and HR consultancy service post-recruitment placement. Furthermore, in Eltoma, we have expanded our services portfolio by entering into the property market. We have a number of unique properties on the market in Cyprus for investment opportunities. Should you wish to find out more about any of the properties on screen or other properties that we have listed on our website, you can do so by entering your email address in the chat box on screen, and one of our property agents will revert to you shortly. Alternatively, you can visit, as mentioned, the link shown on the slide, which is www.eltoma-property.com. Now, I'd like to thank you all for your time and attendance, and I hope you've enjoyed this webinar. Thank you very much.